Welcome to literary and jury charge practice. Let's get started with some jury charge practice. The subject of this jury charge is reply to appeal for probation. Ready? It is a fact that we do err, and it is a fact that man is tempted to commit offenses against himself and others, but not all of us repeat some of the offenses over so long a period of our lives, and to the end of depriving other people of the right to their property. That you sought out your confessor, sought advice from him, and followed that advice to achieve peace with God is something that all of us would be happy to be able to say. However, confessing your guilt to the Lord is only one aspect of it, and the court is still left with a duty to perform, a duty that the court is obligated to perform. The court is obligated to do all we can that is fair and just to the people of the state of Illinois, and in justice to the complaining witnesses and to the defendant in this case. The court feels that obligation to society as well as to you. With respect to the offenses brought forth here, you have presented practically no defense. The court would like to accede to the request of your counsel and put you on probation. It might be that your frank confession and your efforts in cleaning up your offenses is your defense. However, you have an obligation to society as well as to yourself in this case. In indictment number 59291, the sentence will be the Illinois State Penitentiary for a term of not less than 1 year and not more than 10. In indictment number 59292, the sentence will be the Illinois State Penitentiary for a term of not less than 1 year and not more than 10, and to run concurrently with case number 291. In indictment number 59293, the sentence will be the Illinois State Penitentiary for a term not less than 1 year and not more than 10 years, which sentence will run concurrently with cases 291 and 292. In indictment number 59294, the sentence will be the Illinois State Penitentiary for a term of not less than 1 year and not more than 10 years, which sentence will run concurrently with cases 291, 292, and 293. And in indictment number 59295, the sentence will be the Illinois State Penitentiary for a term of not less than 1 year and not more than 10 years, which sentence will run concurrently with cases 291, 292, 293, and 294. Now, if the parole board sees evidence of your rehabilitation, you will undoubtedly have such consideration as the case permits. I do hope that they permit you to go out under supervision for a period. However, you will not forget what you said here today about trying to make restitution. That is the sentence of the court. Let's get back to some literary material. The article is called Family Ties. Ready? Sarah works part-time at the Douglas County Courthouse with her mother-in-law, Mary Kay, and also freelances. Miranda, now managing reporter in Shawnee County, opened a voice writing program March 2 and is making sure the family ties continue. Her stepdaughter, Kiana Cummings, and sister-in-law, Carrie Cummings, are attending Miranda's nighttime school, adding 2 more branches to the family tree of reporting. Mary Kay and her husband Lee have 5 children and 8 grandkids and travel whenever they can. Mary Kay has worked at the Douglas County Courthouse since 1976, retired 3 judges, and hopes to retire when her current judge does. I have been blessed to have some very good judges to work for, which always made it easy to enjoy my work, she said. Vesta recounts that she invited Mary Kay to work in her freelance firm years ago, and Mary Kay answered, "You've bossed me your whole life. Why would I want to come to work for you?" Vesta responded, "I didn't think I was that bossy." And although Mary Kay has plenty of court reporters in her own family to share war stories with, she still keeps up with her friends from school. In fact, they met for a 40-year class reunion this summer with their teacher in Colorado. Reporters came from California, New Mexico, Texas, Missouri, and Kansas. Mary Kay could have told about the time she was informed by the sheriff's deputy in court that her dress was caught up in her pantyhose after she walked in front of counsel, the jury, and spectators, or the time she put her phone down the front of her shirt when she went for a walk during lunch, forgot it was there, and returned to her big criminal case only to have the phone start ringing. All right, let's practice this legal opinion that we had started. And this again is the legal opinion from a speed contest that was originally read at 230 words per minute. But no, I will not read this at 230 words per minute. No worries. All right, ready to go? Here we go. Dr. Washington determined the defendant's brain disorder would not have been diagnosed if he had not had an MRI scan after the accident. Finally, both the defendant and Mr. Barker testified that they could not recall any details of the automobile accident. The trial court denied the defendant's motion to dismiss the indictment. His motion to suppress all evidence obtained immediately after the accident showing the presence of alcoholic beverage containers in or around the defendant's car and statements indicating the defendant and his car smelled of alcohol, and his motions for a directed verdict of acquittal. The trial court further denied the defendant's proposed jury instruction, regarding the insanity defense, to which defense counsel objected, determining that the defendant's blood alcohol level did not establish that he was under the influence of alcohol. The trial court instructed the jury to find the defendant was not intoxicated at the time of the accident. Likewise, the trial court directed the jury to find that the defendant suffered from a brain disorder affecting the consciousness regulating portion of his brain. This literary is called, the title is, I'm a Court Reporter and I Play One on TV. Ready? More television shows are including court reporters in courtroom and other scenes, but working reporters know the chagrin of seeing an inaccurate portrayal. Several shows have been using real court reporters as extras to bring in some authenticity. Recently, NCRA members Sarah Linder and Cindy Sebo, RMRCRR, have had their small screen debut playing the court reporter on television. For me, the best part of this experience was just art imitating life, said Sebo, a freelance reporter from Bowie, Maryland, who appeared on House of Cards. I was a court reporter for the House of Representatives, and here I am playing one on TV. The two members had slightly different paths getting the part. Linder's appearance on Nashville was prompted by the show calling Elite Reporting Services, located in Franklin, Tennessee, where she works, looking for a real stenographer. One of Sebo's friends went to a casting call for House of Cards, where she heard the show was looking for a court reporter. The friend encouraged Sebo to submit a profile which included her credentials and photos of her steno machine. A few months later, I got a call from the casting agency telling me I was hired and what I would be doing, said Sebo, who played the court reporter writing character President Frank Underwood's State of the Union. The agency was particularly interested in her experience working at the House of Representatives. Linder was given instructions on her wardrobe and when to show up for Nashville. House of Cards was using footage from a previous State of the Union, so Sebo had to match the court reporter from the footage, including wearing a wig. They were very particular about matching me as closely as possible to the court reporter, she said. They showed me zoomed-in pictures of the real court reporter, including her hair, her jewelry, her suit color, her steno machine. Sebo added that it was particularly surreal that she recognized the court reporter from the photos. All right, back to some jury charge material. subject of this jury charge is admission of evidence. Ready? Prosecutions for conspiracy present difficulties and temptations familiar to anyone with experience as a federal prosecutor. The difficulties derive from observance of the rules governing evidence admissible against some but not all defendants in a criminal case. The temptations derive from the advantages of prosecuting in one trial two or more persons collaborating in a criminal enterprise. One of the most recurring of the difficulties pertains to incriminating declarations by one or more of the defendants that are not admissible against each others. The dilemma is usually resolved by admitting such evidence against the declarant, but cautioning the jury against its use in determining the guilt of the others. The fact of the matter is that too often such admonition against misuse is intrinsically ineffective, in that the effect of such a non-admissible declaration cannot be wiped from the brains of the jurors. The admonition, therefore, becomes a futile collocation of words and fails of its purpose as a legal protection to defendants against whom such a declaration should not tell. While enforcing the rule of admitting the declaration solely against a declarant, and admonishing the jury not to consider it against other defendants, Judge Hand, in a series of cases, has recognized the psychological feat that this solution of the dilemma demands of juries. He thus stated the problem. In effect, however, the rule probably furthers rather than impedes the search for truth, and this perhaps excuses the device which satisfies form while it violates substance, that is, the recommendation to the jury of a mental gymnastic which is beyond not only their powers but anybody else's. It may well be that where such a declaration, only glancingly as it were, affects a co-defendant who cannot be charged with the admitted declaration, the rules enforced by the court in this case does too little harm not to leave its application to the discretion of the trial judge. Let's look at some of the words in here. We had conspiracy, collaborating, declarant, intrinsically, ineffective, non-admissible declaration, futile collocation, impedes, dilemma, mental gymnastic, glancingly, glancingly. All right. I would encourage you to work on those words and this jury charge. That will conclude our literary and jury charge practice.